All right, we can go off the record. You're going to have to make better choices when you're released from prison. If you can't find a place that will help you with your sobriety, if I'm still here, come here. I'll pick up the phone and call somebody to help you.
This is important. The judge confirms this is no longer contested. That means there won't be a fight over the facts. With an interpreter sworn in and the plea about to change, this hearing is moving straight towards sentencing.
All right, the court is calling 2019 CR 13071, State versus Martin Mendez. Can I have parties announce?
Lauren Espinoza for the state.
Rafael Leal for Mr. Mendez.
And are you Mr. Mendez?
Yes.
We have an interpreter here today. If you could raise your right hand for me, please. Do you solemnly swear? Thank you. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right, Mr. Mendez. I'm going to ask you a few questions because I've been informed by both parties that this is no longer a contested hearing. Is that correct, state and defense?
Yes, Judge.
It is my belief, so Judge.
All right, Mr. Mendez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, so you'll have to wait till the interpreter finishes interpreting. Understand?
Yeah. Yes.
All right. When you were here for this case previously on a motion to revoke, you entered a plea of not true to all of the allegations. Do you recall that?
Yes.
It is the court's understanding that you wish to change your plea from not true to true. Is that correct?
Yes.
All right. Did you review the motion to revoke community supervision and the first amended motion to revoke community supervision with your attorney? Did you understand it?
Yes.
And counsel, have you had a chance to speak with your client about changing his plea from not true to true?
Yes, Your Honor.
All right. And I know we put this on the record previously, but for this time, Mr. Leal, do you speak Spanish?
Yes, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to confer with your client in Spanish?
Yes, Your Honor.
All right. Mr. Mendez, are you the same Martin Mendez who was placed on community supervision in 2019 CR 13071 for the offense of driving while intoxicated third or more on January 13, 2021 for a term of 4 years? Is that you?
Yes.
All right, state you may proceed.
Violated condition number 5 in Bexar County, Texas. The defendant, Martin Mendez, did then and there fail to report to the supervision officer as directed for the months of November and December 2024 in violation of condition number 5.
How do you plead to that, true or not true?
True.
Violated condition number 9A on or about the 18th day of November 2024 in Bexar County, Texas. The defendant, Martin Mendez, failed to report a change of address to the supervision officer within 48 hours in violation of condition number 9A.
How do you plead to that, true or not true?
True.
Violated condition number 40 on or about the 14th day of October 2024 in Bexar County, Texas. The defendant, Martin Mendez, did then and there fail to report to the supervision officer as directed immediately upon release from custody in violation of condition number 40.
How do you plead to that, true or not true?
It is true.
State?
Your Honor, we're asking that
Are you waiving the other violation?
yes, Judge.
Any objection?
No objection.
All right, did you understand by pleading true to violations 5, 9A, and 40, the court could find it true, grant the motion, revoke, and sentence you up to 3 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violations 5, 9A, and 40? Court will
Yes.
find 5, 9A, and 40 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion and sentence to 3 years in the prison, as well as take into consideration cause number 2025 CC 016349. That's awesome.
And is that what defense, are you in agreement with that?
Yes, Your Honor.
Mr. Mendez, are you asking the court to follow that agreement?
See, yes,
Are you waiving your right to appeal?
see, yes,
All right, the court will follow your agreement. The court will grant the motion, revoke, sentence you to 3 years in the prison, give you credit for any time served. There's a 2-year license suspension. And the court will take in consideration 2025 CC 016349. There's $1,000 fine, which is a part of your original plea bargain agreement. Time and money will run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
see, yes,
Because you've entered into a plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
see, yes.
All right, and I'll recommend the therapeutic community as well. Therapeutic community doesn't increase the time that you're in custody. It's a program to help you with any addictions you may have. However, I do not have the jurisdiction to order them to place you in the program. You will still need to request placement in the program. Do you understand? All right, we can go off the record. You're going to have to make better choices when you're released from prison. If you can't find a place that will help you with your sobriety, if I'm still here, come here. I'll pick up the phone and call somebody to help you. All right, good luck to you.
Thank you, Your Honor.
You're welcome. And counsel, you'll need to take that dismissal to whatever court it's in.
Yes, I understand the procedure.
All right, thank you. Good morning. Just give me a moment. Odyssey is being a little fickle today. All right. So the last time we were here, it's my understanding that all discovery was received. Is there anything outstanding on discovery?
Yes, Judge, I reviewed all the discovery that was given to me in court that day. There are a number of items that are not included, although referenced by the detective in this case. I've conferred with the state. She's reached out to the detective, I believe, who will be coming in quite soon to gather the rest of that remaining discovery. I can go through that in detail if you need me to, Judge, but there's a number of things that are still absent. I've also gotten an offer from the state today, so I would just request another time for us to review that additional discovery. We'll sign off on it, and then I can confer with my client before we put it on the trial docket, Judge.
All right, so the additional discovery, is that something you have in your possession or?
Your Honor, the only thing that would be outstanding that I need to call and check on would be lab work.
Okay,
Other than that, everything else, it seems like the detective may have in their possession and they just need to get it to me. It's very voluminous. It's cell phone extractions, Chromebook extraction, Instagram accounts.
so when you say lab work, you're talking about the extractions.
No.
Oh, that's
lab
in
work.
addition to?
Yes, Your Honor.
So lab work and then extractions?
Yes, Your Honor. The extractions have already been completed.
Mhm.
I just need to get them
Okay,
and download them and upload them.
okay.
Should be quite a bit of material, Judge, so I just would request some sufficient time to go through that.
Okay, so, because I'm just trying to be clear, so I'll know how much time to give you. So the lab work, you're waiting to get that from somewhere else,
Yes, Your Honor.
but it's complete, but you just need to get it?
That's what I need to find out.
So we don't know if it's complete or not.
Not at the moment, Your Honor. I did make a phone call. I was not able to reach anybody at the lab at the moment.
Okay. Let me just put this in the system. Third party. Now the extractions, they are complete. You just need to get them in the format to have him view.
Yes, Your Honor. And I do apologize. I'm looking at my list here, Your Honor. It does look like I need to, based on a conversation with the witness, we need to order CHOSA and child safe records, which I believe would take 30 days.
Okay. So how much time are you all asking for?
Reasonably, Your Honor, I believe 45 days would be enough for us to get everything and get it over to defense and then have a little bit of time to review it, at least to discuss the offer with his client.
Sounds reasonable to me, Judge.
All right, so this is what I'm gonna do. This is gonna be your plea deadline date. And if for some reason you don't have the discovery in before this date, y'all gonna need to talk to the coordinator, come back in before this date.
Yes, Judge.
Ms. Ferguson?
Yes.
Give me a 60-day reset. That's gonna be your plea deadline
Thank
date.
you, Judge.
You're welcome.
March 30th.
March 30th?
Yes, Your Honor.
All right, we'll see you all back at March 30th. Once you sign the reset form, you're excused.
Thank you.
Thank you. All right. On this case, a motion to substitute.
Correct.
All right, court is calling 2025 CR 011383, State versus Kendall Nicole Ortiz. Can I have parties announce?
Ashley Jones for the state.
Don Flannery for Miss Ortiz.
All right, and are you Miss Ortiz? All right, so your previous attorney was Attorney Ramirez. The court is in possession of a motion to substitute counsel. Have you had a chance to review the motion? Do you have any objections to that?
No.
And state, you have no objection?
No objection, Your Honor.
All right, the court will sign the motion. All right, so, and since we are here, where are we on discovery?
Your Honor, I do believe all discovery has now been turned over to defense. We signed a protective order for the CPS records last time. I have made those available and uploaded to our e-discovery system.
So obviously now I'll be able to download Discovery and start reviewing it.
Yes, and were you able to tender an offer?
Yes, Your Honor, an offer has been tendered.
All right, Ms. Ferguson, I need a plea deadline date, 45 days. So on this date, when you come back, you need to let me know if you've reached agreement. If you have not reached an agreement, your next setting will be a jury trial date. All right, March 16th will be your plea deadline date.
Thank you, Judge.
All right, is there anything else?
Not from the state, Your Honor.
From the defense, thank you.
All right, once you sign the reset form, you're excused.
Right there.
Hi, how are you going?
Good. How are you this morning?
I'm doing great.
Good.
I've started reading a new book that they're telling me is better than Fourth Wing, but we shall see.
I'm gonna have to get the name from you then, because
Yeah,
that's
I'll make
would
sure I
be
give
hard
it to you.
top.
Yes. All right, so on this case, this first setting,
It is our first setting. We conferred with the state and it is a PTD referral. So I have all the application information from my client and we are gonna submit it either by the end of the week.
okay.
say.
Ms. Ferguson, I need a PTD date. All right, so
I will be, I won't be available that day. If we could do a few days later in March, I'll be there. Yeah, sorry about
okay,
that.
that's okay.
March 9th.
That's perfect. Thank you.
Are you gonna be on a trip though, enjoying your best life?
In the city that you and I have talked about, actually.
Oh, my goodness.
So,
Well, enjoy. That's gonna be fabulous.
I'm excited.
All right, so you're gonna come back on March 9th. It's very important that you make sure all of the contracts are signed and your attorney will tell you, stay in contact with whomever is walking you through the PTD when you get accepted, okay?
Yes.
All right, anything else? All right, once you sign the reset form, you're excused.
Thank you for your time.
Enjoy.
I'll talk to you soon.
Send photos to me.
I will definitely. Thank you, Jen.
Thanks. And I'm sorry, how do you pronounce your last name?
You say Laura?
Okay. Well, I'm trying to make sure I start pronouncing right, so show me no slack when I mispronounce.
It's like you roll the R.
Okay, I can't roll R's yet. I'm working on Laraga. Okay, thank you. All right, the court is calling 2025 CR 007444, State versus Shakira Laraga.
Yes.
Can I have parties announced for the record for the state?
Lauren Espinoza for the state.
Lock for Shakira Laraga.
See, he's trying to show that he can roll the R's, but that's okay. And are you Miss Laraga?
Yes.
Okay. Counsel, have you received all discovery? Did you review it with your client?
I have, and we have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Laraga, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Laraga, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with evading arrest detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
She is, and she was, Your Honor.
Ms. Laraga, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's a $1,200 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, I understand.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
No objection, Your Honor.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
If we could, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, she's 19 years old. She is also currently providing care to her sister, who's 30 years old. She's just has a broken foot, but can't get around, so she's helping her out with that. But I believe she's unemployed at the moment, Your Honor. So any help that you could give us on the fine, we would really appreciate. But this was a situation where there was essentially a panic attack in the presence of the police, and that's why she's taking responsibility for what happened.
All right. So who is Destiny Escalera?
My next friend, I don't associate with her not anymore, but she was just my friend.
All right. And you know there were other things in the vehicle, right?
During that moment, no, I didn't know until after.
Well, I mean, it said that you're the driver, you passed something and put it in the glove compartment and no, that's what it says in the police report. So why are you not employed?
Because I tried looking for jobs and they're not hiring, and currently my sister broke her foot last month and she needs 4 months bed rest, so I need to take care of her and my family can't do it because they work, and she's the only I'm the only one who she could rely on at the moment.
So she broke her foot?
She's wearing a cast and I basically have to take care of her because I'm the only one.
Well, she can't use crutches?
No, it's like she can't like move out. She had broke her ankle, so she can't like move around at all.
But I mean, don't they have, I mean, if it's in a cast, don't they have crutches? Because here's the thing, you're gonna have to get employment because I mean, I'm ordering that. So how far did you go in school?
High school. So I just graduated like last year.
So what are you planning on doing with the rest of your life?
I'm thinking to do like Korean business with lashes or anything like that. Or I'm still looking into it. I still want to go to school and stuff.
So here's the thing, you're 19. Once you hit 20, the years fly by very quickly. And I'm telling you, while you're on probation in this court, I require everybody to have employment. And so whatever your hopes, your dreams, your aspirations are, you need to start figuring that out and you need to have a plan and start not just thinking about it. Well, we say yes, definitely, but how long has it been since you graduated from high school?
Well, this was stopping me because I didn't know if I could find a job with work going on. It was my first time, so I don't know how this goes, but I was trying to look into it.
So do you
continue to?
So I know you say you're helping your sister out, but who's your support system? Do you live by yourself?
I live with my parents, and they're my support system.
All right, do you have any children?
No.
All right, let's not have any until we have our life in order.
Yes.
Okay. All right, this is what the court is going to do. There's a $1,200 fine that will be probated. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. If you're drug tested today, what are the results going to be? And now's the time to be honest with me because I will have you drug tested.
Marijuana, I've been having heavy smoker for a while, but I stopped like a few months. I don't know if it's gonna stay in my system, but it'll probably be positive, but I'm not sure.
All right, we're going to do regular random UAs, tests for levels. Those levels need to start going down. Regular reporting by Zoom or in person. Field visits 1 time per month for 8 months. 120 hours of community service restitution. You can have a choice. You can do those 120 hours and regardless of what the temperature is now, it gets hot in San Antonio, as you know. You can either spend it picking up trash or either you can spend it bettering yourself. So you can either do the 120 hours or either you can obtain some higher level of education or some trade school certification.
To do that as well, I just don't have help to look into it, but I'll keep.
Young people have, you young people have so much information at your fingertips. When I was growing up, we didn't even have computers. And Mr. Locke, I'm sure you remember going to the law school library. You didn't go online. They wouldn't even let you lose Westlaw until you know how to do it looking through books. So go online. Oh, thank you so much. Day labor is hiring. I appreciate that. Thank you. Thank you so much. So you hear that? All right. And then I'm going to sentence you to 4 years deferred adjudication. If you complete everything early, then I'll consider removing you early.
Yeah, I'll get.
But don't come to me if you're not doing what you're supposed to do. You understand? And Miss Abrams, if you do a minus 20 hours, I am going to order completion of the defensive driving course. Probation, is there anything else?
No, sir.
Is there anything else you need from the court in order to be successful?
No.
And also probation, if you can help her with employment as well.
I would definitely need that, please, because I didn't get a job, so I wasn't sure what this going on. I don't know if they're gonna see it, so I've been kind of.
Okay, they'll help you with that and they'll give you,
Gladly take the help.
sure, and they'll give you some programs and where to go, okay?
Thank you
All
very
right.
much, Robert.
Sure. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. From here on out, everything you do, you need to realize that if a motion to revoke is filed against you, you're potentially looking at 10 years in the prison. So everything you do, you need to ask yourself, is this something that could potentially result in me getting a revocation? If the answer is yes, don't do it. If the answer is maybe, don't do it. Communication is very important. Talk to your probation officer. If there's an issue, let them know. If you feel you can't stop using marijuana, call them, let them know, okay? All right, good luck to you.
Thank you, Your Honor.
Thank you.
Thank you.
Her honesty changes the tone. She admits marijuana use before testing. Instead of immediate punishment, the judge responds with structure, random testing, employment requirements, education options, and 4 years deferred. The message: this is intervention, not incarceration, but only if she follows through.
Morning, Judge.
Good morning. How's it going?
Pretty good. New intern for the court.
Yes, this is Paris. This is Renee. Make sure you speak with him.
Nice to meet you.
All right, so why don't I have the motion to revoke? Are you all proceed? It's Kevin Robinson. That's okay.
With regard to the motion, Judge,
Mhm.
I know this is the first setting on this, Your Honor. They're alleging new number 1 on there.
Thank you.
I do need to look further into the protective order, as well as the videos associated with this, to see if they comport with the report, Judge. And I believe that the state is wanting to also look into a more detailed version of the criminal history before proceeding on a possible resolution, Your Honor. So we're asking for a reset of this matter.
All right, what I'm going to do is I'm going to set it for a contested hearing in 14 days. And either it's going to be contested or it's not.
Yes, Your Honor.
Ms. Ferguson, I need a 14-day reset.
May I propose a date that's in line? I think it's maybe a few days past that, February 19th. It's a Thursday. It's my schedule. That's
Sure.
something the court would work with.
February 19th. Is that good, Norma? All right, so we'll set it for a contested hearing at that time. If it turns out it's not contested, please notify the court and the state.
Will do, Your Honor.
All right, you have any questions? All right, just have a seat. They'll give you your reset form, and once you sign it, you're excused. Thank you. All right. We're on the record in 2017 CR 5709 State versus Michael Bissett. Can I have parties announced?
Lauren Espinoza for the state.
Lindsay Shaw for Mr. Bissett.
And are you Mr. Bissett?
Yes, I am.
All right. You entered a plea on October 30th. A plea of true to violations 2, 2, 2, 2, 5, and 5.
Yes, sir.
And we had this case recalled for today. And you were placed on GPS, partial for medical and employment. The court was presented with letters to review by the defense with no objections from the state. Is there any other evidence to be presented to the court? State?
No, Your Honor, we just have prior criminal history if the court wishes to know that.
Defense?
Just, I re-urge some of the argument that was made at our last setting, Your Honor. No other evidence.
All right. Any objections to the court reviewing the court summary?
No, Your Honor.
No, Judge.
Let me see.
I actually have it.
Thank you. All right, here. Thank you. All right, state you're recommending revocation. How much time are you requesting?
We're requesting revocation, judge, and sentencing for 5 years in the prison.
All right. And defense, what are you requesting?
Well, Judge, as the court's aware, this probation expired in 2022. But I guess what we're requesting, Judge, and if the court would recall the testimony from my client in October, he had a warrant for many years. However, he didn't pick up other cases. He was gainfully employed. He owns a landscaping company. He takes care of his 19-year-old daughter who has terminal cancer. She receives treatments through his VA benefits. It's through the TRICARE program. And I can offer, I think he might have something else he would like to say to the court, but he has a lot of people that care about him and that he supports, and he's not standing before the court and not taking responsibility. He's fully aware that he made the wrong decision, but that he is asking for forgiveness from the court and to give him another opportunity.
And did you provide the medical information to the state?
I did not do that. I can offer through my client, if the court wants to hear about what kind of condition.
No, I think he needs to give medical information to the state, and then who knows? Maybe the state will ask for something other than revocation. But we were supposed to come back here for part of the things the court wanted was medical.
I didn't know that was requested, but yes, I can get that now.
Right, that needs to be done today.
Yes, sir.
So we'll recess till 1:30, and you need to come back at 1:30 with that information.
Yes, ma'am. Thank you, Judge.
Okay, thank you. All right, so he's scheduled for jury trial on February 17th.
That's correct, Judge.
Right. I'll have to make a correction because I see where it says February 17th, 2025. I'm like, why hasn't this happened?
Although this is a case we've had back and forth about discovery with juvenile records many times, and
Oh, yes.
that's still unresolved.
I thought they had a hearing or something over
We had a
there.
hearing, the judge allowed us access to one file. And then when we requested, they say we can't find the file under that file number. Well, we can't get file numbers or case numbers because we can't get access. Recently, Megan provided me with a list of about 10 or 15 SAPD numbers in the hopes that getting those might get us what we had been asking for at juvenile. They wouldn't give us. I put in the request to the city. I'm waiting for a response. So, although I think the response is going to be, no, you can't have it. I'm almost sure.
It makes no sense, but
Well, it's because they're juvenile records. But anyway, we're here for another tangent issue. I've asked for a bench warrant for the co-defendant juvenile.
mhm.
And I didn't want you to say, why are you asking me on trial date for that? So I'm doing it today.
Okay.
And I don't know where he is. For some reason, he's a juvenile.
All right, state, he's saying that he wants to bench warrant a witness and it's a juvenile. Do y'all have any access or somebody where he is located?
I can try to ask the juvenile prosecutor. I mean, I would like to represent to the court that, I mean, I've been doing everything that I can to help Mr. Martinez get this evidence, but I mean, I don't have the access to it myself.
All right, we can go on the record.
Okay.
The court is calling 2024 CR 008-124, 2024 CR 008-173, 2025 CR 007-834, State versus Christian Allen Ruiz Garcia. Can I have parties announced?
Megan Galloway for the state.
Raymond Martinez from Mr. Garcia.
And are you Mr. Garcia?
No.
All right, so we were discussing off record issues with discovery, and that's related to a juvenile, and you're wanting to review the juvenile's file.
Correct.
All right, so the record can be clear. If you can explain for the record or state on the record why you feel that's material that you have a chance to view all of those records.
Okay, Judge. And if you don't mind, I'm going to go backwards a little bit to prior hearings we've had in this court. As you recall, this court tried to facilitate that scenario by setting up a Zoom hearing where the juvenile prosecutors appeared on the record on Zoom and told this court directly in no uncertain terms, you can't have those files and you can't see those files. He just said no. I said, okay. Then I later learned that I could petition the juvenile judge who handled those cases and ask his permission. He gave us permission to look at the one file that coincided with my client because the juvenile was accused of doing like 15 aggravated robberies. My client was only involved in one episode, right? Well, first of all, allegedly. The problem is the point of me looking at those other files is we've alleged a defense of duress, and we've explained to the state why we've done that, and we're all on the same page about why that might be the case. So in order to flesh out my client's state of mind and whether he was under duress, I wanted to be able to demonstrate to the jury what this other kid was doing, what he was capable of, whether he was carrying a weapon, whether he shot everybody, all those different things that would give some context to why my client felt like compelled to participate in the limited manner in which he did. Problem is, they gave me access to the one file that I do have access to because I have access to his files. All those others, they said no. So not only did they tell you no, the juvenile judges told me no. They've told Ms. Galloway no. And they're gonna continue, I think they're gonna continue to tell her no. But today was me continuing to perfect my record in regards of all the different places I've been stonewalled. My hope in bringing the co-defendant, the juvenile, is for him to tell the jury, no, I don't know Mr. Garcia. No, we didn't plan this together. We didn't go to school together. We're not friends. To further show this, he's not a party to this case.
Let me ask you, does anyone know who was the juvenile's defense attorney?
And we've spoken to him, Judge. Abe Garza was a lawyer,
Okay.
and he has not wanted to be forthright in disclosing. I think for the same reason. He feels like if the court can't disclose it, I as his attorney shouldn't be doing that. And so he's kind of politely stonewalled as well. So yes.
Well, is he still the attorney of record or has he withdrawn? Because if you are able to bench warrant him or her, they're going to need an attorney appointed to
Yes.
represent them.
I think he appeared at the hearing in front of the juvenile judge on our request for discovery. So yes, I would say he probably still is. The hearing that we had a month or two, well, before the holidays, it's been a while, where we asked the juvenile judge to give us access. Yeah, he was there at that hearing.
All right, let's do this. Let's go off the record briefly. If someone has Abe Garza's number and see if he can appear maybe by Zoom.
No, Judge, if I'd have been a little quicker, I saw him earlier.
Yeah.
Might have even been in here, but
Oh, let's
We'll
call
try.
and see.
okay.
All right, thank you. All right, who's next?
Thank you, Your Honor.
You're welcome. Yes.
Yes, Judge, you brought us back for a status on our, this is a case where we're working on a plea, but the prosecutor had to go upstairs.
Mhm.
We're super close. Trial date, we have a trial in a few weeks, so everyone's ready, but I think we might be able to get this resolved with counteroffer going upstairs. So I don't know if you want to bring us back maybe next Thursday and for a plea. I'm pretty certain we're going to have a plea that day.
All right, Norma. We call this for February 5th for a plea.
You did.
Thank you.
Thank you, Judge.
You're welcome. All right, the court is calling 2025 CR 011500 State versus Christopher Ray Martinez. Can I have parties announce?
Lauren Espinoza for the state.
Plano Gaston for defense.
And are you Mr. Martinez? Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
I did, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it? Defense, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the punishment enhancement and also proceed on the lesser included offense of possession of a controlled substance, PG 1 to 4 grams.
Any objection?
No, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea, the court does not have to follow your plea. If the court gives you more than you bargained for, the fact that you enter the plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Martinez, has anyone threatened you, forced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, the state is waiving the enhancement. They're proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, 1 to 4 grams. Punishment is to be assessed at 3 years in the prison. There's a $1,200 fine. State recommends community supervision. Did you understand that to be your plea?
Yes, I did, Your Honor.
Defense?
It is, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, regular random UAs, and the DOEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the less included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
No objection.
Did you review the waiver and state you may be excused?
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just that we ask that you follow the agreement, Judge.
All right, so how often have you been using?
I had a history, when I was younger. I'm not, I don't be using.
Well, I mean, as early as whatever this case is.
I will
right?
say, Judge, that I have spoken with my client. He is motivated to attend outpatient treatment. If inpatient treatment is ordered, he is willing to go to, he was asking that he go to lifetime recovery. He did find a job. He is currently working and he wants to enroll in SAC. And so I have discussed, was it? Oh, he currently enrolled in SAC. And so he is motivated for treatment. He does acknowledge that he has used in the past. I don't know how
But
recently.
not since he was young.
I don't
like, because how old
I
are
don't
you?
believe that's true.
Okay. So here's the thing. You need to be honest with me, and let me just tell you why you need to be honest with me. Because I'm trying to put conditions so you can be successful. I take no joy in sending people to prison, but your attorney will tell you I have sent people to prison. So if you tell me I don't have a drug problem, I don't use, you know what's going to end up happening? I'm going to send you out the door on your way, and don't come back to me testing positive for drugs. You understand?
I understand.
So I'm trying to figure out what can help you.
Yes, I am currently trying to seek treatment. I was hoping to find outpatient because of school and work. But I do have, like I said, I do have a history of drug use. But I was trying to insinuate that because of like past, I've gone through different stages where I am trying to stay clean and not relapse.
Okay. So what are you studying at?
Social work.
Okay, awesome.
Yes, I'm trying to help change from the other side of the field the best way.
All right. So do you have any children?
I don't have any children.
Okay. So who's your support system?
I have family, parents, and I have a partner.
Okay. So do you live with your partner or not?
My partner, yes.
Okay. And is there any drug use with your partner?
No.
Okay. Well, if you're going to be in that relationship, you're going to have to meet your partner where they are, right? So this is what the court is going to do. There's a $1,200 fine. Time and money will run concurrently. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release. There's to be no employment as a home healthcare provider with minors. TAP evaluation out of custody. Do not miss that TAP evaluation. If you do, that's going to be a violation of your probation. They're going to slide across my desk a motion to revoke. You understand? Sentence you to 3 years in the prison, suspended and probated for 3 years. There's to be 120 hours of community service restitution. 20 of those hours will be, let me not do that. I'm going to deduct 1 hour community service restitution for every sober support meeting you complete. And then there's going to be field visits 1 time per month for 6 months. And probation, follow the TEP recommendations, but if they're asking for inpatient treatment, we'll start with outpatient treatment. And do a referral to Lifetime Recovery. Maybe they'll accept him. Probation, is there anything else?
A referral for Lifetime Recovery inpatient.
Let's start with outpatient and see how it goes. Or can he just go over to Lifetime Recovery?
Yes.
All right, so just make sure you go over to Lifetime Recovery. You understand? All right, thank you, probation. Is there anything else?
Yes, Your Honor, before I go off the record, I have a dismissal plea for that.
Okay.
Related to this defendant.
Thank you. Is there anything else that you need in order to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you, this is a PF, that goes with whomever it goes with. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let probation know about it. If you feel they're not addressing it, you can come back to me. Whatever you do, do not disappear. You understand? All right, good luck to you.
Thank you.
Thank you,
You're
Judge.
welcome.
Be excused.
Yes.
It's too late.
This is the turning point. The judge makes it clear, probation only works if she knows the truth. When Martinez admits past drug use and expresses willingness for treatment, the court responds with structure: TAP evaluation, sober support credit, lifetime recovery referral, and strict monitoring. It's accountability with opportunity.